Welcome back. Thom Hartmann here with you. Okay, in the Hobby Lobby case, the court has essentially defined birth control, reproductive health for women as a new and unique area of medicine, separate from all the other all-inclusive medicine that encompasses both men and women. Things like, they said, for example, you can't apply this decision. The religion of an employer cannot be inflicted on their employees if that religion says no blood transfusions or no diabetes treatment. We're going to pray it away or anything like that. That doesn't work. You can only discriminate against your employees based on your religion if they happen to be women. This is essentially what the Hobby Lobby case said. And it was the five Catholic men. And I say that not to diss Catholics, but I do think that, to ignore that is to ignore maybe a 300-pound elephant in the room, who made this decision with vigorous dissent from all three women on the court and Justice Breyer. So that's Hobby Lobby. The other and Conestoga products. The other case that was before the court was. Do you know the name of the case, Shane? Harris v. Quinn. And Harris v. Quinn was this woman who is caring for her son in Illinois, and because she's being paid by the state to care for him, but he's her son, and so she doesn't have a formal employer who defines her hours and conditions of work or anything, but she still is paid by the state. The union... Well, actually, the state passed a law saying that such people are eligible for union employee. In fact, must join the union. And she said, no, I don't want to join the union. I don't want to be part of this union. And here's where it gets interesting. Sam Alito basically came out and said, this is all about taking down unions. I'm PO'd about the power that unions have in the United States. I think it's wrong. I think there's a corrupt relationship between unions and Democratic politicians. And anything that I can do to break that corrupt relationship between unions and Democratic politicians and corrupt Democratic politicians, I'm going to do. And he said this. This is actually the voice of Sam Alito during the oral arguments. When he's debating with the Solicitor General. What was his name? Don Verrilli. Thank you, Shano. This is Sam Alito and the Supreme Court Justice, one of the kings of America, and Don Verrilli, the Solicitor General. Here, listen.
I thought the situation was that Governor Blagojevich got a huge campaign contribution from the union, and virtually as soon as he got into office, he took out his pen and signed an executive order that had the effect of putting, what was it, $3.6 million into the union coffers.
Whatever
that's the sequence. Is that correct?
Well, I think the issue before the court is the constitutionality of the statute.
Right. And so Alito says, I got an agenda here. I want to kick Rod Blagojevich and the unions upside the head. And Don Verrilli says, that's not the issue here. The issue is whether this law is constitutional. This state law in Illinois. And they didn't throw out the state law. Instead, what they did was they legislated from the bench. They said, we're going to create a whole brand new category of employee that is not envisioned in the law. And this new category of employee is a person who, works at home and takes care of one of their relatives and yet is compensated by the state. And that person does not need to join a union. This is not the role of the Supreme Court. Article 3, Section 2 of the Constitution lays out explicitly what the role of the Supreme Court is. And it's to be the final court of appeals. It's not to decide whether laws are constitutional or not. And it is not to create doctrine from the bench, whether it was this case or whether it was Roe v. Wade. This is, where are the right-wingers who were screaming about Roe v. Wade being judicial activism? It was. They were saying the judges are legislating from the bench. They did. They defined arbitrarily three trimesters, well, with some medical information. But basically, the Supreme Court said there are these three different trimesters during pregnancy, and we're going to apply different rules to each one of these trimesters. That's a whole different thing from saying Jane Doe could or couldn't have an abortion, and just simply limiting it to Jane Doe, which is what the Constitution says the Supreme Court should do. And what Newt Gingrich and Phyllis Schlafly and all these guys were running around at the time in 73 saying, oh my God, oh my God, oh my God, judicial review, judicial overreach, judicial legislating, blah, 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 blah. Where are they now? Is Fox News going to run a whole day of outrage because the Supreme Court is creating law? Because that's what they're doing. And it's not in their portfolio. Even constitutional monarchies, Great Britain, the Netherlands, Norway, Denmark, Sweden, the sovereign in those states, the kings and queens of those states, of those countries, does not have the power to strike down law or to create new categories of workers or new categories of health care or anything. And neither do their Supreme Courts. This Supreme Court, our Supreme Court here in the United States, starting in 1803 with the Marbury versus Madison case, and then 50 years later, 1856, in Dred Scott, have decided that they are the kings. This is no longer a democratic republic. It is a constitutional monarchy. And you know what Abraham Lincoln said to Roger Taney, the Chief Justice of the Supreme Court, after the Dred Scott decision? In effect, with his behaviors, he said, well, that's really sad for Mr. Scott. We can't free him. But I'm going to free all the rest of the slaves. In other words, the Supreme Court's decision doesn't apply to anybody except the case in front of them.